Hi, Marcus. Long time no hear. I'm glad you're here. Professor McGowan, thanks for joining us. All right, are we ready to get started? I bet we're going to have people continue to join as we get started, but we'll go ahead and let them get settled in. I want to say hi, everyone. I'm Haling Ortega, Pro Bono Coordinator at Legal Aid of Arkansas. I want to thank everyone for being here with us today. Um, Today, our CLE program is estate planning and heirs property. And I will be serving as your moderator. We also have Casey Copeland, our pro bono director, who will be monitoring the chat and available in the background. He will come on a little later and offer some closing remarks. Just a couple of housekeeping notes before we get started. As you know, today's session is being recorded. After the program, you can expect to receive your certificate of attendance, evaluation form, and you'll also be provided with today's presentation materials. Please use the chat box to submit questions, and we'll reserve time at the end to address as many as possible. And with that, we'll go ahead and get started. We have our presenter today, Tye Boudra-Bland. Tye is a staff attorney with Legal Aid of Arkansas with a primary focus on heirship property cases. Tye is a 2025 Bowen School of Law graduate and also holds a master's degree in history, reflecting his background and previous work as an Arkansas historian. Please join me in welcoming Tye.
Thank you, Haley. I'm very happy to be here and be able to talk about heirs property with you all. There won't be a lot of estate planning talk. We will be doing a bit of a refresher. And so saying that, we'll go ahead and get into the roadmap of what we're going to be talking about today. So, like I said at the very beginning, we're going to be going a little bit over estate planning and how it relates to the transfers of real property that influences how heirs property comes up and how these issues are persistent in Arkansas and across the nation and what we're going to do to address them. After that, we're going to be able to define heirs property and give a little bit of the background of heirs property and where this has come from and kind of where we are now. And with that, we're going to be able to kind of see where the issues are developing and where they're based. And after that, we will then outline the problems and specifically in Arkansas what problems are and how we're trying to deal with those problems now since this is a area of law that we're recently trying to address and it's something that's been very prevalent for the past 150 years. And then at the very end, we're going to try to offer some general solutions and try to showcase how these issues that are very diverse, very diverse and very expansive. Um, Try to offer some solutions of how to address those issues. To give a little bit of a spoiler, there's no perfect solution, but if you take nothing else away from this, prevention is the best way to even stop heirs property issues from arising. As you'll see as we go through, the reasons that this becomes an issue is because people do not handle their affairs prior to death. And whenever that happens, they will oftentimes leave multiple heirs with multiple claims to the same piece of land, and the people that they leave the land to do the exact same thing. And that becomes the issue that then exacerbates into a major problem by the time that you've gone even 2 or 3 generations down. I'm dealing with some allergies, as those of us in Arkansas can understand. It's very pollen heavy around my house. So if you hear me sniffling, if I cough, if I take a drink of water, I ask your forgiveness, and I'm going to do that now before we get into the refresher. Okay, thank you. All right, again, this is very generalized. We're only talking about real property, and we're only talking about people failing to really address
Right now,
how
like
these things go
poor
before
people.
they. I think somebody's unmuted. Sorry, we're talking about how these things affect real property transfers because the issues of heirs property are that you have land that's been transferred to you that's just not in your name and you really can't do anything with it. So with estate planning, we're talking about wills that are able to transfer real property or beneficiary deeds as a way to transfer property upon death, trusts that people set up and put land into good use or land use trusts if you have farmland or something else. And the purpose of what we're talking about here is to control the distribution of property at death. We're really wanting to see that someone is able to take care of their affairs before they die, so that way this heirs property issue doesn't arise whatsoever. Unfortunately, it has reared its ugly head, and we're trying to address it. And so, whenever you don't choose how your property is going to be divided up whenever you pass, as all of you know, it goes through intestacy. And that is the state's default rules of how these pieces of property are distributed. And so a little bit of the intestacy is, generally speaking, again, very generally, wills or having some other property transfer means you die testate. You have a means of transferring the property that the state recognizes. It allows people to get their names onto new deeds, and they are the recognized legal owners of land. Excuse me. If you don't do that, if you do not have a will or any other means to do it, then you are dying intestate, which means that that will go to the state's default rules. Now, what is heirs property when we talk about this? Heirs property generally is land that's passed down through intestacy, which means that there's no will, there's no probate or other recognized legal transfer of the land. And so if you look at the name, the heirs or that individual's descendants. Typically, they're children. Um, and then the property would be the real estate that they owned at their death, the real estate, the real property that they own. Heirs property is most known for and characterized by fractionalized ownership, the interest that we see in the property questions of old of someone has 10 heirs and that one heir has 10 more heirs and now you've gotten three generations down and there's 1/64th interest. That's what we're talking about when we talk about heirs property as a nightmare scenario. But heirs property also applies to anyone who inherits property through intestacy. So, who are the heirs? Heirs are determined using default rules. Each state has their intestacy rules that demonstrate, or excuse me, that illustrate who is going to inherit when someone passes without a will or other means of property transfer. And so in Arkansas, the heirs are typically the decedent's children. That means that if they have one child, if they have multiple children, all of them will then inherit the property as tenants in common. This means that each heir owns a share of the property, not a specific parcel of the property. They can all agree to parcel out the property after getting a survey and splitting it up and seeking a partition, but it does not come that way as a default. And a lot of times when we're dealing with clients who are inheriting property, they struggle to understand this concept here. And so I want to spend just a minute talking about why it's important to discuss this now. When we have heirs who are tenants in common and we're trying to explain to our clients what's going on, it's very important that you convey that they are co-owners of the property, even if they have been paying property taxes, even if they have been upkeeping the land, even if they've been, trying to maintain records for their most likely deceased mother or father. It's very common for people to assume that if they've been paying the property taxes, if they've been the ones taking care of the land, living on the land, staying on the land, that they own it outright. It is theirs. And that's just not the case. A lot of clients that we have will struggle whenever they are trying to talk about the tenancy in common, whenever we're discussing that, they struggle to understand and to be able to really want to make amends with maybe some estranged family members or others in their family who they haven't talked to in a very long time. As you'll see a little bit later, when we're dealing with heirs property, what we're doing is trying to understand who all are the owners. Like we talked about just a second ago, when we have multiple heirs, and especially through multiple generations, it's very common for individuals not to be able to just recite a phone number or an address right off the top of their head. They don't have a lot of contact with extended family, even though they are co-owners. And when we're talking with clients and trying to get this information from them so that way we can send notices, we can try to maybe send disclaimers or otherwise get to have contact with them so that way we can explain what we're trying to do with this piece of real property that, someone oftentimes a single individual has been taking care of. The individual just doesn't have access to that information. They don't have access to phone numbers or addresses for these people, and they're really reliant on extended family members, hopefully remembering where these people have been able to move to. And a common problem that we'll run into is we have maybe a name, maybe where they used to live or something like that, and then we're trying to do our own people search and make contact with people through through letters or things like that. It's a very time-consuming process. It is very intensive on time. It is very intensive on research and trying to understand the family dynamics of what's going on. Um, so when we talk about heirs inheriting as tenants in common, it's very important that you convey that you may not know all the owners, you may not have regular contact with all the owners, you may have problems with the other owners, but at the end of the day, they are co-owners. And when we want to transfer the property or make major decisions, we're going to need their consent and approval generally in writing, so that way these things can be handled. Otherwise, we're going to run into an impasse where the property can stagnate or just continue to be of little use to the people who are actually working on the land, living on the land, and trying to use the land to their benefit. Excuse me. Thank you. Okay. So a little bit about the history of heirs property and how we got here. Until the turn of this century, it was a very little known problem. There's 150 years of predatory partition law practices that really went under the radar. It was not something that people understood that they really could contest. There was no procedural or structural safeguards for them to be able to try to hold on to this property that they had. And this issue led to fire sales. The process generally looked like this: a speculator, land speculator, real estate agent, or something like that could purchase a fractional share in the property. All they have to do is get somebody's share. Generally, they would target black and brown communities and estranged family members to try and find one small share of the property to then be able to seek a partition. As we know, you can ask for a partition if you are a co-tenant, and they abuse this process. They would try to seek out anyone that they could find, get buy up, speculators would often buy up shares that maybe had no worth whatsoever. They would record it, they would get the interest validated, and then they would seek a partition through the courts. Goodness. And historically, partition sales were favored. There's two kinds of partitions: partitions in kind, which means that you each get a piece of the actual land and that's divided up equally or equitably, and then partition sales, The sales sold the entire piece of property, regardless of whether or not someone wanted to stay on the piece of property or if they wanted to live on the piece of property to use the piece of property as a co-owner. They sold everything, including the people's homes where it would live. And that was favored because of the ease on the courts. They were able to put the property up for auction. They would then sell the property and split the proceeds, generally very, very far below fair market value among all of the co-tenants that they could find or list. And that is where we have major issues in land loss. And the lack of notice, the lack of proper commercially reasonable advertising practices led to these depressed sale prices that were far below fair market value. Lots of people lost land for pennies on the dollar and were never able to recover that or to be able to deal with the physical moving of their entire lives in this situation. It was incredibly prevalent, and it disproportionately affects Black and brown communities, and specifically the African American community. Since 1910, there's a study that came out, and I believe it was in 2010 or 2019. I cannot remember off the top of my head, but since 1910, 90% of Black farmland was lost. That's over 14 million acres were lost to these predatory practices. This is a little known problem with huge implications that has far reaching effects across our nation. It is not localized to the South. It is not localized to the Midwest or, where we think of big wide open spaces. This is a national problem that has been abused for the past 150 years. And that said, the turn of the century in 2001, there was an Associated Press article entitled Torn from the Land. In this article, the authors detailed these predatory practices. They showcased what was happening within the African American communities and how they were losing huge swaths of land, how it was something that they had no procedural or structural safeguards against, how they were often just handed a check at the very end of the day after the property had been sold with no knowledge that they had any interest in the property whatsoever. They were most times caught off guard. Very often they were struggling to be able to understand the process and be able to understand how these things have affected them. And so there was excuse me, the Uniform Law Commission then read the article, they got together and they decided that they were going to try to do something to remedy these predatory practices. And they drafted the Uniform Partition of Heirs Property Act in 2010. And to date, 26 states have enacted some version of the UPHPA. It's a majority of the country now, and it has a majority of the population that it covers. And Arkansas adopted it in 2015. And a little bit later on, we'll go through the Arkansas specific statute and kind of what they classify heirs property as and the procedural safeguards of what they're doing. And that'll be the bulk of our presentation of trying to understand these processes, understand the statutes and how it affects heirs property and how we can try to find the solutions that we've had to deal with for these past 150 years. So, what drives heirs property? What are the factors that are here that make heirs property something that is so prevalent across the country and such a big issue? And again, I want to reiterate this is a national issue, and it has been a national issue the entire time. Even though we have a great deal of farmland here in Arkansas and we focus on being the natural state, this is not localized to us, even though it has been a huge issue across our state. Every state in the South, every state in the Midwest, in the Northeast, across the country have had to deal with these issues. It is not something that has been unique to any particular region of the country. These practices have been prevalent across the nation. And they tend to adopt a predatory stance. And so they try to target areas with lower socioeconomic value. The reason being is they want to try to buy up these pieces of land or potential interest in land for pennies on the dollar. They do not want to try to pay fair market value, so they're trying to extract as much value as they can by seeking out the different lower socioeconomic areas within a particular region. While that's not the only way that they've done it, there have been big problems with this in Dallas and in some other major metropolitan areas where there are significant heirs issues where lots of people are not able to make a will or estate plan prior to death. And so when they're conveying property, when they're moving property, they don't know that they have multiple heirs and that they've inherited a fractional share from their parents before them. And so these things can be very diffusive. They can spread very rapidly throughout this context. And these predatory practices also really try to leverage the fact that there is a general lack of access to legal services in these rural areas. Like we mentioned before, 14 million acres of black farmland have been lost predominantly in lower socioeconomic areas because there is no access to legal services in these areas. And historically, they've not been allowed access to these areas. They have been barred from being able to utilize legal services. And these predatory practitioners knew that. They have targeted these areas to try and find, like we've talked about before, find small fractional interest and then be able to seek a partition. And also, this has led into a negative feedback loop where the people within these localities and within these areas have a very strong distrust of the legal system. They do not appreciate whenever individuals try to tell them what they know or try to come in and do a little bit of help and then immediately move on. To discuss a little bit about this, there have been other heirs property projects that have tried to go into like rural Arkansas, Mississippi, and Louisiana, for instance, and be able to make community connections and be able to talk to the individuals that this affects. There have been numerous instances of people having heirs property issues where they've been able to talk to an entire family and try to sit them down to mediate with them to address the issue. And there's just been a general apathy or a specific and affirmative distrust of the people who are trying to help them. And that is from the historical practices that we've had before. Let me take a drink of water really quick. Excuse me. And so, even though this has been been trying to be addressed since the turn of the century, there is rebuff, there is pushback from the other side, so to speak, because of what has happened before. It's not something where people trust that you're going to be able to come in, solve all the problems related to the property for them, and then they get to go on their merry way. They do not believe that that is something that's going to happen, and it takes a lot of legwork to be able to establish trust within these communities, to show consistency, to show up with them, to sit with them and explain the processes, the procedures, the meanings, and the help them understand what's actually going on and not just what it feels like's going on. And there's also a driving factor in the disparities of estate planning that is combined with this issue. If you distrust the legal system, if you distrust what's going on from people who do not take the time to talk with you and do not explain things to you and have no recognition or understanding of your lived experience, it is incredibly difficult to get that person to trust you with anything, not just heirs property, but anything related to their property. Speaking a little bit to my practice, there is a client that we have that specifically in his family, they have passed down property through intestacy intentionally. They view it as the most fair way to be able to handle property issues because it, in their eyes, links back to the original owner of the property, and it's a way to honor them and be caretakers for their land. So this is not something that is small, that is trivial, that is something that can just be kind of glossed over. It takes dedicated effort and dedicated time to be able to sit with these individuals to overcome that inherent distrust of the legal system that has essentially disenfranchised them for so long. Excuse me. And kind of to highlight this issue, there is a huge disparity in will making. And I'll let you guys take a look at the chart. But in general, this is only talking about if a respondent to the study has a will, and then it's broken up between the average as well as the averages based on education level. And so the respondents from the study, for everyone included, regardless of race or ethnicity, was just a little over half of those individuals had a will. And that tracks with how much education they had. If you had a lesser amount of education, you generally were not as likely to have a will. The more education, especially post-secondary education that you attained, the much greater chance that you had to have a will. You see that there's like a 56.9, almost 57% on average that have a will. And if there is no high school education, that drops below half. And if you go to, excuse me, if you have someone who has a college degree or more, they're going to be much more likely, almost two-thirds of those individuals have a will and have a means of being able to transfer their property. This becomes the contrast becomes even more stark here whenever you break it up into the different races and ethnicities within our nation. For instance, if you look at white populations, almost two-thirds had a will that responded to this survey. Almost two-thirds just out of the gate. That's significantly above the national average. And whenever you look in relation to the national average versus white population without a high school education, those are almost on par, almost equal, which is leading to these huge disparities in heirs property disproportionately affecting Black and Brown communities. And that for white populations with a college education or above, almost three-quarters of them have a will or other means to be able to, or excuse me, have a will. And that tracks for being able to navigate within the system, being able to have access to the system, and being comfortable with the system. If you contrast that with the Black community, their average was less than a quarter of having a will. And the only significant jump that we have is for Black individuals who attained a college education or above and who were able to have access to that. And then it goes to barely under one-third. This is a incredibly prevalent problem and goes to show the levels of distrust in the legal system and in the conveying of property, the transferring of property within these communities, because they simply have not been able to have access and they no longer have the baked in trust for the system in the same way that other populations do. So, that being said, that's the history. That kind of gives you an idea of where we've come from and what's been going on in this situation leading up to this. And so this leads us to the next part of here's the problem. Heirs property ownership is an incredibly unstable form of ownership, one of the most unstable forms of ownership. Whenever you inherit the property and you are considered an heirs property owner, it is very likely that you do not have any idea that you are an owner of this property. If you are the son or daughter of someone who owned the land outright in their name, it's likely that you understand and you have an understanding that you have some piece of the property. But whenever you get to that person's children and then their grandchildren, and what we often see in these heirs properties cases, these individuals have no idea that they have an ownership stake in a piece of land. Sometimes the first inkling of an idea that they have is a letter that we would send or someone else would send to them that says, "Hey, you have an interest in this land. Do you want to disclaim that interest? Do you want to assert that interest and work with the owners who live on the land? Do you have any affinity for the land? Do you have any connection to this land?" And they're presented with a problem of, I didn't know that I was a part owner. Now I am. What do I need to do? Am I expected to pay taxes? Am I expected to pay for upkeep? What if I don't want to deal with the land? What if I don't want to have any connection to this land? What if I don't even know who these people are? And that can lead to further distrust of the system, not understanding what's going on, and a general apathy related to the property. Oftentimes, in our practice, we find that we can send out letters to individuals who we can verify that they have claims. Maybe they've even had extended family contact, but they do not respond to letters. They don't respond to phone calls. They generally just want to be left alone because they don't trust that this is the services or the processes we are offering or trying to be able to handle can benefit them. And this type of ownership can lead to entrapment and it can lead to deadlock because it takes unanimous consent to do anything major with the property. You cannot sell it if everyone's not on board. You can't do other things if everyone's not on board. And if there are co-owners and co-tenants who do not want to have anything to do with the property and will not give up their claim to the property, you run into this deadlock where individuals, even if it's a majority of the ownership, want to do something with the property, whether it's sell it, whether it's repurpose it, try to use it for a different land use. They're unable to, and they are not able to access funding. They're not able to be able to utilize loans or anything like that, and run into, like I was saying, this general deadlock where the property just sits. And the only people who really get to make use of it are the people who can afford to make use of it or who can't afford to move elsewhere, that are just landlocked and unable to do anything. Um, excuse me. And heirs property owners also almost always lack clear title to the property. They are not named in deeds that have been transferred, and even if they are, it's oftentimes that they are the only one listed on the deed, even though there are several other heirs who should be listed. This presents a huge problem whenever we're trying to transfer the land or we're trying to make beneficial use of the land, because the first thing that anyone wants to know is who owns the property. And then you have to get into the very convoluted discussion of, this is actually my grandfather's property that we've inherited through my mother's side, and it's now gotten down to us, and we want to be able to make use of the land. Very common for individuals to come specifically to us or to try to take care of these issues when there is a pressing need. For instance, if there's been a disaster, a tornado or a flood, they're not able to have access to the funding that is meant to help alleviate those stressors and those consequences of the natural disasters because they don't have clear title to the property. They don't have a way to demonstrate ownership of this piece of land, even though they've lived on it their entire lives. And it's the same with their parents and their parents before them. Even though they've effectively known nothing else, the record system doesn't recognize them as owners because it recognizes the original owner as the sole owner. And you have to do an extensive search and family trees to be able to try and make sense of who even has a claim. This also lends itself to land loss and involuntary land loss through delinquent tax sales. This is a very common issue that you'll have, is because generally whenever the land is inherited, there's one individual, maybe one or two individuals of these group of heirs who take care of the property. They pay the property taxes because that's what their parents were able to do for them. They showed them how to do it. They know that they have an interest in the land, even if It's not on title, and so they pay the property taxes. But what happens whenever that person dies? What happens whenever that person no longer is paying the property taxes that they've been paying for 10 years? The land, the property taxes then become delinquent, goes to the commissioner who then sets it for sale, and the only record owners who get notice are the immediate heirs of the original owner. So maybe their children, but that's only if they have been keeping up-to-date records, if they've been paying the property taxes with updated addresses and submitting new information to demonstrate that it's not the original owner, it's a new owner, or it's not the original taxpayer, it's a new taxpayer at this address, and that's where you should send notice to. And then once the sales are finalized, there's no contesting them. It's a done and dusted deal, and there's nothing that they can do, and they're stuck in a situation where they did not realize that they were vulnerable. They thought everything would be okay, and now they do not have the land that they've been trying to take care of. And so these are some of the problems that we face with heirs property. So some practical considerations that we have are the heirs are determined at the time of death. And that is important because if you have an individual who has children but dies after one of their children has died, then you have to try to do the age-old property questions of who actually gets the interest and who passes on. Did the child of the owner have any children themselves? Did they have a spouse, or does that interest revert back to the general pot between the rest of the siblings? And this also is an issue because heirs are not considered until, generally are not considered until there's a transfer of land, a sale of land that's desired. And this happens years or even decades after the original owner dies. We've had a situation where someone has been made aware that there is a transfer of land, there is a sale of the land, and they live on the land and they don't understand how the land has been sold from underneath them and they were never told. They never got letters, they never had any sort of notice and have no understanding or being able to, or they have no resources to be able to contest this issue. I mean, these are very prevalent problems that they've been struggling with the entire time. Forgive me. Also, it's important to remember that family memories are short and they can be short. Grudges can last a lifetime, but the memories on who has what and where it was and where the records are, or if there's a will, if there's a deed, or things like that, are very short because if it's not something that people deal with regularly, it's not something that they're going to think about until there's a big to do, there's something that is pressing, and they have to try to address it right then. There's also the issue of public records being incomplete because of fires, for instance, or moving buildings and things get lost in translation because these are records that go back for, like I said, decades at times. There's been a case that I've worked on where the original deed was granted back in the 1800s. You know, this is post-Reconstruction, Gilded era, where they have property and it's never been transferred into anyone else's name. And suddenly we're trying to understand and track down the original deed and the original owner's children and who died when. And you can see how this problem can become exacerbated incredibly quickly and snowball into something that people just do not want to deal with and would rather just let it go, throw up their hands, let it have its sale, instead of trying to assert their rights and to be able to stake their claim in the land. And to that end, these fractional interests can split exponentially. It's something where it's not even that the original grantor has to have 10 children for this to be an issue. If you have just six descendants over the course of two generations, then you're going to have very difficult problems because oftentimes you'll have situations where people, like I said before, do not keep in touch. They don't know this extended family. They have no way to contact them. They just know generally they're somewhere in a different state, or they went to the West Coast, or maybe they went back to the Northeast, or something of that nature. And they have no way of contacting these individuals, which then puts a lot of pressure on you as the attorney to try and do your best Sherlock Holmes impersonation and find these people and try to dig up any clues that you can. Um, all of these things generally lead to clouded title. And whenever you have clouded title, there are significant restrictions on accessing federal, state, and private loans. Whenever these loans are given out, typically they want to have some understanding of who the record owner is to be able to ensure that they have a proper record keeping. There are also restrictions on obtaining home insurance, which, like we talked about, can affect disaster relief whenever a tornado comes through or there's a flood, and they're not able to insure the home because they're not a record owner, even though they've been living in the same house since they were born. And now they're faced with a situation where the home is destroyed. They don't have a means to be able to repair it or to build a new home or even to move, and they're stuck and the land is stagnant and there's not really much that they are able to do. There are also restrictions on homestead credits for property taxes and who gets to claim those whenever there's clouded title. And like we've mentioned several times, there's general restrictions on the transfers of property because whenever you have a tenancy in common, it requires all of the tenants to be able to make a joint decision about what to do. And that, even if you try to get three people to agree, can be a huge issue. These are some of the very significant, prevalent, pervasive problems that people have had to deal with over the past 150 years. And like we've mentioned before, it's led to significant losses of land, of farmland, millions and millions of acres for people who have faced these issues. And after the publication of Torn from the Land in 2001, there was significant push to try and remedy these things, to try to come up with a system to kind of bake in structural and procedural protections for these individuals so that way they were not unhoused or disenfranchised in the same way. And so, to that end, we'll talk a little bit more about the Uniform Partition of Heirs Property Act, specifically here in Arkansas. It was enacted in 2015, effective January 1 of 2016, and it classifies heirs property as at least one co-tenant acquired title from a relative. And then two, there has to be significant family ownership. And they define significant family ownership as either 20% or more of the interest held by co-tenants who are relatives, 20% or more of interest held by individual who satisfies the bullet point one above, or 20% or more of the co-tenants are relatives. And that is significant because they are trying to allow the people who have been using the land, have lived on the land, have ties to the land to be able to assert a claim and to assert these structural and procedural protections that we're about to talk about. They did not want to make it a higher bar, a greater percentage, because they were worried about the predatory practices of the past and how these things have influenced the transfer of these interests before. And they did not want there to be a situation where, for instance, a major corporation or a private equity or anything like that could come in and buy up just enough of the percentage points to be able to form an ouster and to sell the property or force a partition. They bake these in so that way the bar is not low, but it is just a fifth of what would be considered 100% ownership to help, like I said, bake in these protections. So, what are these protections? What are the cornerstones of the UPHPA? Number one, and arguably the biggest, is the co-tenants who wish to retain ownership have the option to buy out the co-tenant who requests a partition. And this is huge. This is something that cuts directly against the predatory practices that have come before. No longer can you come in, buy the 164th interest, and demand a partition and then be refusing a partition in kind, which is something that we're about to discuss. This protection allows the co-tenants who can jointly or individually wish to retain ownership to buy out the co-tenant who requests a partition. And they have a formula that will go out on the next slide, but it is a means of being able to stop the predatory practices of the past, and specifically buying a small fractional share and then demanding a partition sale where the prices are going to be depressed. And in two, the act also codifies the preference for partition in kind over a partition sale. The reason that they do this is because in heirs property, you will often have multiple individuals, multiple heirs who live on family land, on large tracts of acreage that is just their family estate. And so the protections are meant to protect them from the default of a partition sale that was a de facto default. Like I said before, courts favored partition sales for their ease. You post notice, whether it's at the courthouse or in the newspaper, you have the sale where generally very few people show up to be able to actually make bids. Once the sale's over, for generally fire sale prices, you split the proceeds between everyone you've identified and you go about your merry way. This protection favors the partition in kind over the partition sale. And there are several factors that tie to the history of the land, the use of the land, and the living situations on the land. And we'll discuss a little bit more of those in just a minute. But then we also have, if there's no buyout that can happen, if we do have to do a partition sale, then there's going to be an open market sale for that piece of property. And we'll go a little bit more into that later. First, the buyout procedure to buy out the individual or the co-tenant who is requesting the partition. First, the court will determine the value of the property and they will seek out an appraiser who will determine the fair market value of the property. They will not do or excuse me, they will then seek out the interest of the party seeking partition, whatever that percentage interest is. They multiply those two things together, and then that's the buyout price. So if you look at the example at the very end, I love round numbers and it's easy. $100,000 value, fair market value, 3% interest, which these fractional shares can get even lower. That's $3,000 to be able to buy out the tenant who wants the partition. Their interest then gets looped back into the broader pot and distributed amongst the rest of the heirs. So that way they can do that instead of having to try to send out individual checks to every single person through a partition sale. Now, we're going to talk a little bit more about the factors for the partition in kind. They're supposed to use a totality of the circumstances test, something that we've loved from law school. As a baby attorney, I love it. And the long-standing ownership is one of the predominant factors that they used. If the same family or the same successive generations of a branch of the family have been there, that weighs and cuts heavily in their favor. They also look at the proportions of payment for upkeep and how these things have been divvied out amongst the family. Is it one individual or one or two individuals who have been maintaining it and keeping up with the land and paying for all the improvements, paying the property taxes, and trying to address those issues? The court will also look at the economic and the non-economic harm from a sale. Economic harm, it will be things like what is the value of the home that you're going to lose, etc. The non-economic harm looks more towards the sentimental value of the land. Like we've mentioned before, oftentimes these are tracts of land that have been within families for generations, multiple generations, decades, and very long stretches of time. These are pieces of land where people grew up, they've always lived on, and they have every intention of dying on. And so the court will look and favor those instances. And then they also look at living situations on the property. Is there a family who currently resides there? Are there multiple families who reside on the land? And there are other factors that they do as well. But these are kind of the big ones. Excuse me. And then lastly, if we do have to seek out a partition sale, what they will do is appoint a licensed real estate broker to list the property. There are no artificial deadlines for this, and I think that that's very important. They are bound to use commercially reasonable practices to market the property, to sell the property, and to leave the property listed for as long as is required or as long as is needed to get a fair market value price. They And historically, there were problems with short notice deadlines and periods for to be able to sell the actual property. And those are gone and done with. Um, they also allow contingent bids to give people time to secure financing through third parties so that way they can try to make claims for the property or other means to do that. And so this is part of the solutions that have been baked in with the UPHPA. But there are also other remedies that we can discuss that are outside of that, and these are related more towards trying to work directly with our clients. The easiest, the best, the hardest is to consolidate ownership. That requires trying to in touch with as many people as you can who you know have a claim and talk to them about the property. Just do they know anything about it? Do they know that they have an interest? Is there any ties that they have to this land? Is there any reason that they would want to assert a claim to this land? Or if they've never heard of it, if they've never been there, if this is, extended family, would they be willing to disclaim their interest? Or, quit claim deed their interest back to the person who's living on the land, who's keeping up with the land. Some other common uh, remedies that we've seen that generally relate to like a beneficial use of the land, if it's a farmland or a procedure like that, are trusts and LLCs, where a third party is the one entrusted with the upkeep of the land, and then families are able to divvy out dividends and proceeds from the use of the land. And then lastly, there are tenancy and common agreements, which are just contracts among all the tenants that you have on how they're going to pay taxes, who's responsible for what levels of contribution that you have, um, what levels of contribution are expected, etc. Excuse me. And a part of the solutions are addressing the needs for heirs property owners. The number one need is access to attorneys. These are typically in rural areas. There are already a lack of attorneys in the rural areas, and specifically, there's a lack of attorneys who deal with these types of issues. We've had clients come to us who have gone to their local attorneys and they were turned away because the issues are too complex, they're too time consuming, and there's just in their eyes, there's no benefit to trying to deal with the monolith that heirs property work, specifically heirs property cases, can bring onto an attorney. Clients also want to have a practical legal education. Like we mentioned before, they don't understand what tenants in common are generally. They don't understand why someone who lives multiple states away has the same exact ownership interest in the land that they've had and farmed and lived on for their entire lives. So giving them kind of the bare bones and just a general understanding of what's going on really benefits everyone whenever we're trying to work through these heirs property issues. We also try to find ways to get financial resources for taxes, for title clearance, and for the land use goals that they have. And attorneys can also solve as mediators for internal disputes within family. It's very hard to get multiple successive generations and multiple interests to all agree on one thing. And attorneys have the unique ability to be able to meet with everyone, explain what's going on, and then try to resolve the issue without going through litigation where everyone has to try to pay for that and deal with the time commitments and the long drawn out procedures that tend to happen. And then the owners themselves really benefit from support networks, peer support networks, and ongoing mentorship from other people in similar situations. There have been a number of situations where people have been able to form peer groups to explain what's going on, to help them build family trees, to get the necessary documentation, seek out deeds, death records, etc., for them to be able to understand what's going on. And when they do seek out an attorney, whether it's on their own or they're being forced into it, they have the necessary materials, the understanding of what's going on, and they feel more confident when they tackle these issues. Um, and that's kind of where we are. The last thing that I want to give you is the resources that we've used that you can look up yourself. The best resource that I've used is this book here, if the thing will focus. And that's the book that's listed here in the middle, Heirs Property and the Uniform Partition of Heirs Property Acts. I want to thank you for your time, and I'll turn it back over.
Thank you, Ty. And we just want to, from Legal Aid, we want to thank everybody for joining us today. I know we're right up against the hour, but do also want to remind you and invite you to join us as we continue to work on it, expanding access to civil justice in Arkansas. Many different ways to do that. You can, join us as a pro bono volunteer. You can come to a clinic and sit down with clients on a one-day basis and help out as a volunteer. Many other opportunities for pro bono services. I'll put some of those in an email that I'm going to send everyone here in just a few minutes to give you some links for other information. But if you've got questions about this issue or any other issues that legal aid faces, we kind of have an open door policy. If it's something that we can help you understand to represent your clients or figure out a legal issue, we're glad to help. And that's just kind of one of the general services that we like to provide to fellow attorneys in Arkansas. So I think, Haling, I think I saw one question in chat that we want to put to Tye.
Yeah, so the question in the chat was when I took property about 5 years ago, my professor told us that statistically more Black Chicagoans owned land in Mississippi than Black Mississippians. Is that still the trend?
I don't know the specific numbers, but I would not be surprised, and I understand the sentiments. And that's kind of what we've talked about a little bit today, is that a lot of the interests in these lands have passed down through generations to people who have absolutely no idea that they even have this interest or that they've inherited this interest through intestacy from their families, which again kind of goes back to the problems that we have of trying to seek out these heirs and to be able to get them to either disclaim their interest or otherwise be able to transfer their interest to the people who are actively using the land and living on the land. But like I said, don't know the numbers, but I 100% agree with the sentiments.
Does anybody else have any questions they'd like to ask? Got about 2 more minutes.
And if not, again, we just want to thank everyone for being here. This is a service that Legal Aid is going to continue to work on and improve. More CLEs are coming this year and into next year with expanded programs. So keep an eye on our website and our Facebook, and we'll also try to make sure to promote these through local bar associations and through the Arkansas Bar Association. So thank you all very much. And Tye, thank you so much. You did a wonderful job. Very informative, especially, even to me who works with legal aid on a daily basis. There's a lot of stuff that I didn't realize as well. So thank you, Tye.
Thank you, Time. Thank you, everyone. Just as a reminder, you'll receive a certificate of attendance, evaluation form, and the materials from today's presentation. Thank you so much. That concludes today's program. Thank you so much for joining us and have a great day.